So we could start our program. एक minute, sir.
Yes.
Anup Mugri, sir. Am I audible? Okay, so we are going to live right now. Okay, please take a charge, Pratiksha.
Yes,
Pratiksha
sir.
Bhosle
Yes,
Kaldone.
sir. Pratiksha Bhosle here.
Okay. So anchoring, you may start from your point.
Okay, sir.
Okay.
Good afternoon, everyone. Myself Pratiksha Bhosle. On the behalf of Ismail Sai Mullah Law College, Satara, I would like to welcome you all on the fourth lecture of JMFC and CJD lecture series. Today's lecture topic is our IPC definition offense against body and property. It is a great pleasure to welcome Honorable Shri Sambhajirao Patil Sir as a guest of honor today. So, on behalf of one and all present here, let me extend a welcome to you, sir. Now, I would like
Thank
to
you.
request Pratiksha Kaldone to welcome the address and introduce our today's guest. Over to you, Pratiksha.
Good afternoon, everyone. Myself Pratiksha Kaldone. On behalf of Isma Saib Mullah Law College Satara, I welcome you all to JMFC CJD lecture series. The topic for today's lecture are IPC definition offense against body and property. It is a great pleasure to welcome Honorable Sri Sambhajirao Patil sir as a guest of honor today. So, on behalf of one and all present here, let me extend a welcome to you, sir. Honorable Sri Sambhajirao Patil Sir, ex-DYSP Satara. His qualification are MA English with gold medalist 1983. Also, he has been completed LLB, MBA, MJ. 1983 to 2018, Sir has been professor along with being a PS and promoted to Deputy Superintendent of Police. In 1999, Maharashtra state government has honored him with certificate of appreciation for the rehabilitation of project victims of revenue department. On 26 January 2004, he has been honored by Honorable President of India as a for quality police service. On 15th August 2004, he has been honored by the Director General of Police State of Maharashtra for the best constitutional records with symbol of merit. On 4 December 2015, All India Police Duty Meet of 2015 was held in which he secured second position and silver medal with rupees 15,000 prize for written test in criminal law and investigation procedure. From 31st December 2015 to 2018, he has hold the post of Deputy Superintendent of Police in Police Training Center, Suruchi, District Sangli. He has been invited as a Speaker of Honor in Yashwantrao Chavan Institute of Science, Satara, Law College, Pune, Police Research Center, Pune, Maharashtra Police Academy, Nashik, Forest Officer Academy, Kundal, and many more. That's all. Thank you. Over to you, Pratiksha.
Thank you, Pratiksha. Now, I would like to request Honorable Sri Sambhajirao Patil Sir to guide us. Over to you, sir.
Yes. Good afternoon, all my dear students and respected teachers. I would like to introduce you that myself as only a student of Ved Shiksha Samstha. Right from 8th standard, I have studied in the institutes of branches of Ved Shiksha Samstha Satara. I have completed my 8th to 10th standard from Mood High School and 11th to BA from Pandharpur College, which also is a branch of Riyadh. Now, I have been staying in Satara since 1996. However, I am not well acquainted with the staff, though my daughter Rohini Patil has passed the LLB examination from your college, and she has been now working as judicial magistrate first class right from August 2016. My second daughter, Poonam Patil, is also a student of Rayat, and she is also product of Rayat, and she has stood first as DYSP among girls in the MPSC batch 2016, and she is also working as Assistant Commissioner of Police. And my son is also preparing for MPSC. I am very well acquainted with, criminal laws. Especially, I have taught all these Indian Penal Code, CRPC, Evidence Act, and various criminal laws to, various police training centers, academies, and I have a great pleasure to be with you today. Really, the topic is, given is very important, and Indian Penal Code, especially every act, when you want to read, when you want to, understand any law, any act, then you have to study first the definitions. You have to understood the meanings, hidden meanings, and the meaning with illustrations. Then only you will understand the further, I mean, explanations, further provisions under this act. So, broadly speaking, I would like to start right from Indian Penal Code Section 6 to 15, 52A. Section 6 to 52A. Okay, wherever you will get amendment in the form of Section 52A or 29A or 304A, 304B, 498, that is only the amendments done after the implementation of Indian Penal Code from 1st January 1862 till date. Okay, the sections, especially from Indian Penal Code, which are important, that is Section 10. Section 10 is very important and it defines the man and woman. It means man and woman means it represents the beginning of human being as well as the birth of a child. Okay, so woman denotes and the man denotes the following meaning. The man denotes male human being of any age, and the word woman denotes a female human being of any age. Here, the word of any age is very important. Even a male child of 1 hour, 1 day, or 1 month is also a man. Okay, and even like that, a female human being of 1 hour, 1 day, 1 month year old, whatever it may be the age, it is woman. Okay. Now the definition of transgender is not given in this Indian Penal Code. This is newly derived term. However, unless and until man proves or transgender proves that he or it is a woman, transgender will be treated as a man. Okay. Whenever a question of law comes into problem, the transgender has to prove that he is not a man, he is or she is a female, then only the scientific certificate, medical certificate should be produced. Take for example, in B district, in police services, one boy was recruited as police constable. Later on, the boy had undergone a plastic surgery and the boy became a girl. And then he claimed that she wants to be a woman police, join as woman police, and she should be treated as woman police. The matter went to the High Court. And when the biologically and medically it was proved that this is now a woman, okay, then only the woman police designation was given to that boy. So like that, transgender is not defined. However, it should be treated as a man when the question of law comes into force. That is why you will say that how a complaint of 1 year baby for the outraging of a modesty or an offense under POCSO Act will be registered against a man if that man commits any offense with the baby or the girl of 1 month old or 1 year old. It is only because of this definition. So section 10 is very important. The question, that is objective question, may be asked to you: what is the age of man or woman under section 10 of IPC? Then your correct answer will be like that: a male person or male human being or a female human being of any age is a man or woman. So keep in mind, any age is very important word and you have to keep in mind. So questions are asked in this manner. मराठीमध्ये काय अजून मधून सांगितलं चालेल का मुलांना? सर, हॅलो, कॅन यू अंडरस्टँड?
Yes, sir.
Okay,
Yes,
no.
sir. Yes, sir.
Yes.
Marathi.
Yeah, whenever you feel that Marathi translation is necessary or Marathi explanation is necessary, you can ask me. Okay. Then section 11 is also important. 11 is also very important. It is defined as a person. Person is a neutral word. Okay. The word person includes any company or association or a body of persons, whether incorporated or not. Whether incorporated or not is very important word. And what is the body of persons? Body of person means when two or more persons forming a particular unity, it is known as body of person. Even the word gang also includes two or more person, but the gang means the gang which is doing illegal activity. The person means the body of persons does not mean that immediately they are doing illegal activities. I will give you a simple examination, a simple example. In any small villages of village panchayat elections, people say that या गटाची बॉडी निवडून आली, त्या गटाची बॉडी निवडून आली. बॉडी मीन्स व्हॉट? ही बॉडी ऑफ पर्सन्स. म्हणजे या ग्रामपंचायतीमध्ये अमुक एका पक्षाचे 7 उमेदवार आले, दुसऱ्या एका पक्षाचे 8 उमेदवार आले, त्याला बॉडी ऑफ पर्सन्स म्हणतात. सो कीप इन माइंड, बॉडी ऑफ पर्सन मीन्स 2 or more persons coming together and doing any activity, whether it is legal or illegal, they are known as body of person. So you have to understand the word person includes not only company, the person includes any statutory body, any company or any body of persons, whether it is incorporated or not. Then section 19 is very important. Who is a judge? Okay. And meanwhile, section 14, I have forgotten to tell you, who is a servant of government and who is a public servant. These two words are very confusing. So here section 14, servant of government, the word servant of government denote any officer or servant continued or appointed or employed in India by or under the authority of the government. So who is the government? Government means the state government or the central government or Union of India government. Okay, the honorable president or the vice president or the governor of state or union territory, they are also known as government. And when the governor or the honorable president of India has appointed anyone or has continued in his service, any person as a government servant is known as government servant. Though his second part is also there, that he is also a public servant, but he will be known only as the servant of the government. And section 21 defines about public servant that we are going to study. So here the word government is important. Who is the appointing authority? Is the government. Governor means Honorable President of India or the Vice President of India or the Governor of the states or the Lieutenant Governor of the Union Territories. They are called as the government. And when the person is working in his office, in the official residence of the Honorable President or the Governor, then he is known as the servant of the government. So that is section 14, and this is always asked to compare who is called as a servant of government and who is a public servant. Okay. Then section 19 is also important. Judge. The word judge denotes not only every person who is officially designated as a judge, but also every person who is empowered by law to give in any legal proceeding, civil or criminal, or a definitive judgment, or a judgment which, if not appealed against, would be definitive. A judgment which is confirmed by some authority would be definitive. Who is one of the body of persons which body of person is empowered by law to give such a judgment. So judgment writing or giving any order according to the judgment, the person who is lawfully authorized is also called as a judge. Okay. So that is why your, examination, advertisement also explains that civil judge junior division and judicial magistrate first class. So judge does not mean only the judge from the session court, or judge does not mean only the judge from the high courts or the supreme courts. Okay, so section 19 is also important, and section 20 is also important. Court of justice. The words court of justice also denote judge who is empowered by law to judicially alone, or body of judges which empowered by law to act judicially as a body when judge is a body of judges acting judicially. When two judges division bench, or 3 judges bench, 5 judges bench, 7, 9, or constitutional bench, then this is also called as a court of justice. And now let us go to very important definition under IPC is a public servant. Public servant, there are 12 categories which are defined under section 21. Those are called as public servants, and this is a little bit different from the servant of the government. That is section 14. Here the public servant is, broadly defined in 12 categories, and you have to go each and every category, but I will explain you. The words public servant denote a person falling under the following categories. When any officer is appointed in government defense forces, there are so many central government defense forces, that is Army, Navy, Air Force, paramilitary forces. He is appointed by the Honorable Commissioned Officer, is always appointed by the Honorable President of India. They are also, that is called as public servants. They public servants who are working in the offices of the courts or judges, including judge is also a public servant, or any juryman or assessor or a member of panchayat assisting the court of justice, or a public servant is also called as a public servant. Then every person who holds any office by virtue of any government appointment. Let us see, any authority which is registered under the Companies Act. Take for example, MSEDL. Okay, Maharashtra State Electricity Distribution Limited Company. It is a company which is earlier known as MSEB, but now it is not a board, it is a company. Okay, the employees working under this MSEDL are also public servants. Even Maharashtra State Road Transport Corporation is also a government undertaking, and for the last 3 months, we have been watching the strikes done by some of the workers from the or employees from the MSRTC. That is why ST buses are not flying in a number of, expectations. So these companies are registered companies by the state government, and the employees working in these corporations or the company are also public servants. However, the sarpanch of village or the nagar adhyaksha or the mayor of municipal corporation, whether he is a public servant under IPC section 21, can you reply this question? Whether the mayor or the nagar adhyaksha or the sarpanch of village comes under the definition of a public servant under section 21 of the IPC. Please reply. Otherwise, my lecture will be one-way traffic. Can you reply? No. Okay. I will answer without wasting my time. Mayor or the member of Nagarpalika or Mahanagarpalika or the Sarpanch or the village panchayat is not a public servant under IPC. But he is a public servant under Prevention of Corruption Act. Prevention of Corruption Act 1988. Here he is a public servant because he is taking some, remuneration, legal remuneration, or some kind of dearness allowance for attending the meetings. That is why under the Prevention of Corruption Act section 2, he is public servant there. But he is not a public servant under IPC. Though even a member of parliament or a member of legislative assembly is also not a public servant under IPC. Though they are getting some remuneration right from 1,50,000 to 2,50,000. They are public servant under the definition of Prevention of Corruption Act. So please take into consideration that 12 categories of the public servant which are explained under section 12. You have to go each and every detail of the 12 categories. I will go to next section, which is very important. That is section 22 of the Indian Penal Code, that is movable property. What is movable property and what is immovable property is also explained here. The words movable property are intended to include corporeal property for every description except land, things attached to the earth, permanently fashioned to do anything is attached to the earth. Take, for example, any electrical pole which is permanently fixed in the ground or on the ground, then whether this electricity pole becomes a movable property or immovable property. Because movable property is a property which is, not attached permanently to the land or to the earth. Okay. Then it is called a movable property. This electricity pole is permanently, kept in the land or in the earth, and that the wiring is also completed and electricity is also going on through the wires. Then it is immovable property. Okay. Even the tree, here let us see, here in my compound of the bungalow, there are 2 mango trees. Okay. These trees are also immovable property because these mango trees are permanently attached to the land or to the earth. Whenever the mango tree will be cut with any instrument, then it will be detached. It will be detached from the land, and then it becomes movable property. But the building where I have been speaking now from my bungalow is is an immovable property because it is permanently attached, permanently structured with the earth of the land. So movable property is only the property which can be moved from one place to another place. Okay. So I think you might have understood the meaning of the movable property and the immovable property. Now these two words are next very important. What is wrongful gain and what is wrongful loss? Section 23. Wrongful gain is a gain by unlawful means of property to which the gaining is not legally entitled. The gaining is which is not legally entitled. Suppose I have a neighbor. Okay, Mr. Chavan is my neighbor. He is having coconut trees. Okay, and he had gone for a picnic for 2 days along with his family members. And when I go to that, coconut tree and bring some 5 or 10 coconuts from the tree, then it is also a theft as well as it is a wrongful gain to me. It is a wrongful gain to me and wrongful loss to Mr. Chavan, who is my neighbor. Okay. So these two, definitions are two sides of the same coin. Okay. When there is a wrongful gain to someone, there is a wrongful loss to another person. So you have to keep always in mind, when there is a wrongful gain, there is always a wrongful loss to another person. So section 23 is also very important to understand. Then gaining wrongfully or losing wrongfully is also explained there. But now another two similar words. Here the students or the MPSC gives confusion among the students. Section 24 and 25. What is dishonestly and what is fraudulently? Dishonestly म्हणजे अप्रामाणिकपणे आणि फ्रॉडुलंटली म्हणजे कपटाने. तर व्हॉट इज द डिफरन्स कपट आणि अप्रामाणिक याचा आपण अभ्यास करूया. डिसऑनेस्टली, whoever does anything with intention of causing wrongful gain to one person or wrongful loss to another person is said to do that thing dishonestly. For example, if I talk to this, Pratiksha Bhosle, that I am retired DSP, I am also advocate, and I have some contacts. I will give you some questions which are to be asked from the MPSC examination, prelim exams. But you have to give me rupees 1 lakh or 2 lakhs. Then I know that I am cheating. I am causing wrongful gain. I am taking wrongful, profit from Pratiksha Bhosle. And after some time, Pratiksha Bhosle gives me 50,000 rupees. Then I give only 5 or 10 questions or answers, and not a single question is found in the examination or the question paper. Then 50,000 loss is done to Pratiksha Bhosle and 50,000 gain is done to me. So this act is called a dishonest act, because right from the beginning, I myself know I am doing cheating, I am deceiving Pratiksha Bhosle. Then it is called as dishonest. Dishonest. Okay, and now what is fraudulently? Fraudulent means a person is said to do thing fraudulently if he does that thing with intent to defraud, but not otherwise. Here the intention is not to cheat. Here the intention is to do any kind of damage, any kind of loss to that person. Okay. See, I have neighbor. Okay, they have also good, plant inside their bungalow. I am unable to grow such kind of plant, but I go on from the compound and I cut that plant and throw it there only. I didn't take it to my house. Then it is called as fraudulently, because there is no gain to me, but there is some loss to there. And in dishonest activities, both activities are simultaneously going on. Wrongful gain to Sambhaji Patil and wrongful loss to Pratiksha Bhosle was seen in section 25, that is called dishonest. Okay, and that is why the basic ingredient of cheating under section 415 of cheating, that is deception and wrongful loss and wrongful gain. But in fraudulent activity, there may not be gain to me, but I am doing some loss to other person. Then it is called as fraudulently. So please keep in mind section 24 and 25, which always confuse in the examination. Okay, next is very important, reason to believe. Always any judge or any magistrate has to give explanation why he has a reason to believe. A person is said to have a reason to believe a thing if he has sufficient cause to believe that thing, but not otherwise. There must be some reason. Okay. See, Pratiksha Bhosle has a reason to believe in me because she knows that my daughter is a judicial magistrate, my another daughter is a police officer, and she has a reason to believe that yes, Sambhaji Patil, if he has a daughter as a magistrate, then he will give me some 10 questions which are likely to be in the examination. Then that is why she has given me 50,000. So there must be some cause to believe, and that is called a reason to believe. Okay. Then section 27, which is not studied by all the students, but this is very important from the definition of theft. When you try to understand the definition of theft under IPC 378, then you have to read section 27. That is very important. Property in possession of wife, clerk, or a servant. So here, when a property is in the possession of a person's wife, clerk, or a servant on account of that person, it is in that person's possession within the meaning of this code. See, I have a wife. I have also a servant. I have also a clerk in my office. Okay. I have given some 10 gram of gold ornament to my wife, okay, as a gift of New Year 2022. But this 10-gram gold ornament which is given to my wife is not the property of my wife. It is always in my possession. Okay? Because section 27 says that if a wife goes to and if I have taken the 10-gram gold ornaments without informing my wife, and I have sold it in the market, wife cannot file a complaint against me about criminal breach of trust or under section 379 of IPC, that is theft. Okay, because the property which is in the possession of wife, or the property which is in the possession of a servant of the person or a clerk of the person is always in the possession of the owner. So that is what also important. Okay. So is there any question up to section 27? Please let me know. Otherwise my lecture will be one-way traffic, sir. Is there any question about section 27? Section 27 particularly. आहे का कोणाला काय प्रश्न? मराठीत विचारा. म्हणजे माझ्या पत्नीच्या किंवा माझ्या नोकराच्या किंवा माझ्या क्लार्कच्या किंवा व्यवस्थापकाच्या ताब्यात मी एखादी वस्तू दिलेली आहे, तर ती वस्तू ती माझ्याच ताब्यात आहे असं कलम 27 प्रमाणे गृहीत धरलं जाईल आणि त्याच्यासाठी त्यांची संमती पुन्हा ती घेण्यासाठी मला लागणार नाही. हे कलम 27 आहे. म्हणून बऱ्याच वेळा एखादी पत्नी पती विरुद्ध जर तक्रार द्यायला गेली की माझे दागिने त्यांनी परत केलेले नाहीत, तर ते दागिने चोरीलेले आहेत अशी तक्रार घ्या. परंतु याला एक अपवाद आहे. जे मुलीच्या लग्नामध्ये स्त्रीधन म्हणून दिलेली प्रॉपर्टी असते, ती प्रॉपर्टी त्या मुलीच्या आई वडिलांनी दिलेली असते आणि ती स्त्रीधन म्हणून दिलेली प्रॉपर्टी किंवा भांडी दागिने काय अजून वस्तू या परत दिल्या नाहीत पतीनं, तर मात्र IPC 406 क्रिमिनल ब्रीच ऑफ ट्रस्ट खाली तो ऑफेन्स होतो किंवा IPC 405 मध्ये डेफिनेशन आहे. हे माहीत असू द्या. पण इथे 27 कलमचं पण तुम्हाला माहीत असणं आवश्यक आहे. Then next section is very important, that is document. Section 29 is document. काय प्रश्न आहे का कुणाला? यस याज्ञिक सर, काय आहे का तुम्हाला प्रश्न? काय प्रतीक्षा भोसले तुम्हाला काय प्रश्न आहे का?
No, sir.
Okay. Section 29, I have dropped section 28, not important. 29 is a document. What is the meaning of document and electronic record? Because right from 2000, the 29A section is added in IPC, that is electronic record. First of all, we'll understand what is document. Document denotes any matter expressed or described upon substance by means of letters. Letters are also important. Figures or marks or by more than one of those means. That is also a document. Take for example, in Satara city, we see some traffic signs which are especially in the round shape or circle board, in a circle shape board. There are some figures written: odd dates parking and even dates parking. Odd dates means 1, 3, 5, 7, 9, 11. Even dates means 2, 4, 6, 8. And that is written on the board that parking only on odd dates here and parking on other side on only even dates. So these numbers also show that it is a document, because traffic sign boards are also a document under this act. Even when you are on national highways or state highways, the milestone also denotes how long Pune it is. Then it is shown as 110 kilometers Pune from Satara. This milestone is also a document. Okay, when we do Panchanama of any motor accident case or road accident, then we also mention what is the milestone number, what it denotes. So this is also a kind of documents. Then if there is any, signboard near your college or school, there is a triangular board, school ahead. What does it show? This board, it is also a document, because it shows that you have to take precaution. You have to be slow. You have to be very cautious. The rectangular board shows that only information. When we pass on the highways, we see a board that toll plaza ahead 1 kilometer, then it is in rectangular form. Then it is only information. Petrol pump ahead 1 kilometer. Hotel ahead 1 kilometer. It is in rectangular shape. That is called also a document. So all these maps, these documents which are marked with numbers, figures, or marks, or more than one of those means, these are also documents. Document means not only such kind of paper, some writings on the paper only, or some affidavit, or some complaint, or some evidence, it or any certificate. I mean, these marks, numbers, letters, and signs which are written on the board are also documents. Even the map is also a document. But then now section 29A, what is electronic record? The words electronic record shall have the meaning assigned under section 2 of the Information Technology Act 2000. The electronic record means the electronic and magnetic waves are passing through the electronic devices and some message is communicated. Take for example this mobile phone, laptop, then pen drives, then CCTV footages, then DVR, memory card. All these are coming under the definition of electronic records, and that is also called as electronic document, but it should be proved along with the certificate under section 65B of the Indian Evidence Act. So this kind of electronic record is also a kind of electronic document, and it is mentioned or explained under the Information Technology Act. The definition which is explained under section 2 of the Information Technology Act is borrowed from that act, and it is inserted under section 29A of the Indian Penal Code. So if you are asked any question, where is the definition of electronic record in IPC, then you have to answer that section 29 capital A of the IPC. But it is borrowed from the Information Technology Act. The question may be asked in this fashion: the definition of electronic record under IPC is borrowed from which act? So you have to answer, it is borrowed from the Information Technology Act 2000. Okay? Yes. Then we will go to section 30 is also important, but you can understand 31 is also very simple. But now section 32 and 33 and 34, these are connected sections. Words referring to acts include illegal omissions. So offense is committed by some act of commission and also acts of omission. Offense, it is defined also under section 40 of the IPC, but here we have to understand that offense is committed by both ways, act of commission and act of omission. Take for example, right from 3rd February 2013, 3/2/2013 पासून भारतामध्ये निर्भया केस नंतर क्रिमिनल लॉ अमेंडमेंट्स ऍक्ट अंमलात आला. तेव्हापासून त्यामध्ये IPC 166 कॅपिटल ए स्मॉल ABC असे सेक्शन ऍड केले. दॅट इज राईट फ्रॉम 3rd February 2013, criminal law amendment has been brought into existence, and section 166 capital A and into bracket small ABC are brought. If a police officer fails to record the FIR given by the victim of sexual assault, then he will be committing an offense under section 166A of the Indian Penal Code because for his omission. Okay, actually offense is not committed by the police officer, but he is doing his legal duty. He is trying to avoid his legal duty. He is legally bound to register the FIR of the victim of the sexual assault, then he is avoiding. He has some political pressure or he has some other, interest, and then he is liable for a criminal case under IPC 166 by way of act of omission. So is it clear? तुम्हाला लक्षात आलं का की पोलीस ठाणे प्रभारी अधिकाऱ्यांनी एखाद्या महिलेच्या लैंगिक अत्याचाराची तक्रार नोंदवून घेण्यामध्ये त्यानं टाळाटाळ केली किंवा उशीर केला किंवा तक्रारच दाखल करून घेतली नाही तर त्या अधिकाऱ्याकडून IPC 166 खाली अपराध होतो. याला म्हणायचं ऍक्ट ऑफ ओमिशन. Most of the motor accidents also take place because of the act of omission, because driving is negligent, driving is rash, he is driving and at the same time he is also talking on the mobile phone. Okay, so this kind of omission to take or drive properly is also an offense under IPC 279 and 304 or 338. So these acts of omission are explained in IPC section 32 and 33 also, and offense is committed with the help of acts of commission as well as acts of omission. And section 34 and 141, these are always misunderstood. What is section 34? Acts done by several persons in furtherance of common intention. When a criminal act is done by several persons in furtherance of the common intention, here the word common intention is important. And under section IPC 141, common object is there. So intention is different than the object. So there are two sides of the same coin, intention and the object. But IPC section 34 explains about the common intention, and section 141 unlawful assembly is about common object. So you have to keep in mind whenever the section 34 comes into picture or in the examination, you have to see that several persons. Here the word several person is also important. Most of the times it is misunderstood that only 4 persons can be booked under section 34. No. Several persons can be booked under IPC section 34 if they have a common intention or they have come with common furtherance, then they are doing illegal act, then they will be liable for the same punishment as the main offense. Okay, this is called section 34. And now we will straightway go to section 39 is also very important. What is voluntarily? A person is said to cause an effect voluntarily when he causes it by means where he intended to cause it, or by means which at the same time employing these means he knew or had reason to believe to be likely to cause it. It means voluntarily means as per his own wish, as per own his consent, or as per his action, he is doing this act, then it is called as voluntarily. If someone is forcing him, someone is threatening him, if someone is giving, promise and asking him to do things, then it is not called as voluntarily. So, whenever the question of voluntarily comes into picture in next offenses, then you have to see the section 39 where the word defined as voluntarily. What is voluntarily? See, if police have arrested any accused person, A is arrested by me also. Take down. I am also a police officer just for some time. I have arrested a person A, and he is arrested for, the case of theft. He has stolen a mobile phone of one student girl from the college. Okay, and I have arrested. Now, after some interrogation or dialogue with the accused feels that, okay, police will find out this mobile. So it is better to hand over. Then he comes to meet me again after 5 or 10 minutes and says that, sir, I want to confess my theft voluntarily. I have not beaten him. I have not threatened him. I have not given any promise. I have given not any kind of false promise also to him. But he is voluntarily saying that he is ready to produce this mobile phone where it is kept. Then it is called voluntary. So section 39 is very important from your examination point of view. And section 40 is also important. Word offense denotes a thing made punishable by this code. Section 40 of this offense is limited only to IPC. But offense is also defined under CRPC also. CRPC section 2 into bracket, another definition. Any act which is punishable under the any law. Under any law is defined under CRPC. Section 2 into bracket N. What is offense? And section 40 of IPC, it denotes that any offense denotes a thing made punishable by this code. By this code means under only IPC. Where there is a punishment, there is an offense. Okay? So any illegal act or illegal act is committed or illegal act is also, registered because of some lawful omissions. So I think you have been getting my points or not. Let us, go to section 44. Let us go to section 44. What is injury? Most of the times, injury is, taken as physical injury. No. IPC section 44 explains that there are 4 types of injuries. So what are these words? The word injury denotes any harm. Harm means physical harm. Hurt means physical hurt. Okay. But most of the students misunderstood that if in a breakup matter or in a breakup in love affair matter, girl or a boy say that I am hurt by my girlfriend or boyfriend. No, hurt is different. Hurt is defined under IPC section 319. That is physical injury, any disease or physical disability. But here emotional injury is definite and it does not come under the hurt. So injury word denotes any harm that is physical injury, whatever illegally caused to any person, to the body that is human body, or to the mind, or a reputation, or a property, Suppose a reputation. I am a retired DYSP. I am also advocate. I was already a lecturer in colleges. I have retired as vice principal from police training college. I have never drunk a single drop of alcohol throughout my life. Okay. I am also not having any experience of any puff of cigarette. Then someone has said that Sambhaji Patil is heavy drunkard, is out of control. It takes at least 180 ml alcohol daily. So this is an injury to my reputation. Okay, this is an injury to my reputation. So when it is caused to your body, when it is caused to your mind, when it is caused to your reputation or when it is caused to your financial matters, that is property matters. Property is damaged. My bungalow or my car is broken by somebody else, then it is also injury. So keep in mind, injury is caused to body, mind, reputation, and any property as per section 44 of the IPC. Now, section life and death, these are also very important words. Also, life means denotes the life of human being. Okay, life of human being, unless the contrary appears in this context. And the death denotes the death of a human being only. Animal, the animal denotes any living creature other than human being. Other than human being. Even insect also comes under this animal. Okay, you are not supposed to, I mean, only it is not animal, it also comes under living creature. So these are the important words. And now last two definitions under section 52, what is good faith and what is harboring. Section 52, what is good faith? Nothing is said to be done or believed in good faith which is done or believed without due care and attention. Underline the word without due care and attention. And the word nothing. Here, two negatives are brought together in this definition. Nothing is the first negative, and second negative is without due care and attention. When two negatives come together, it becomes one positive. So, what is the positive meaning of good faith? That is action which is taken with due care and attention is called action taken in good faith. Oh, take for example, if there is a fire to any house or any building or any commercial complex, okay, fire brigade comes there, fire officer or firefighting officer are trying to take, I mean, all the precautions. They are doing all their level best. They have taken due care. They have also paid due attention towards their activity. However, one of the person, I mean, dies in this fire. They are unable to, I mean, save that person. So here, the action of the fire brigade also officer comes under the definition of good faith, because they have taken all the precautions, they have taken all the care, due care, attention was also provided, but they could not see that person is inside that commercial complex or the building, and they could not save it. So this kind of action is called as action in good faith. So take for example, if you are, I mean, in the college, and if you are, I mean, provided some, I mean, college instruments like laptop or mobile phone, and you are handling properly with due care and attention, and even after that, one of the, I mean, instruments getting, I mean, uh, uh, wrongfully, not working properly, then you are supposed to that you have taken all due care and attention. However, it has happened, and that action taken by you will be treated as action in good faith. So every public servant is supposed to act in good faith. That is, they should work there in the office with due care and with due attention. Then they are supposed that they are doing the official act in good faith. So there will be no prosecution against that fire brigade officer or the firefighting servants. So because they have taken every care, they have paid every attention towards their duty, and that is called due care and attention. Now the last definition, that is section 52A, harboring. What is harboring? Harboring means giving protection, giving assistance, giving, I mean, aid to any criminal. But here the exception is important. and you have to keep in mind that whenever harbor is given, except in section 157 and 130 of the IPC, harbor is given by the wife or husband of that person harbored. The word harbor includes म्हणजे wife. If wife has given harbor to the husband, there is no offense. If the husband is giving harbor to the wife, then there is no offense, except IPC section 157 and IPC section 130. 130 is regarding waging of war. Waging of war. So this kind of, excuse will not be allowed. So 130 is aiding escape of rescuing or harboring a prisoner. If prisoner is being escaping and the wife is protecting, then she will not get benefit. And section 157 of IPC, then it is also like that, harboring persons hired for unlawful assembly. If they are doing illegal activity in the mob or in the riot situation and the wife is trying to hide the husband, then it is of no use. In another matter, wife and husband are accepted. So you will be asked the question of harboring, whether wife or husband is an exception. Yes. Only in respect of the waging of war against India and the offense of rioting. And what is harboring? It includes supplying a person with shelter, food, drink, money, clothes, arms, ammunition, or means of conveyance, that is transport, or the assisting of any person, or whether the same kind as those enumerated in section this. If a criminal is, absconder, if a criminal is not found at his home and he has hidden somewhere else, and if the person knows that he is a criminal, he is a wanted criminal, he is an absconder, and police are trying to arrest him, but the person who has, given him food, drink, or any means of conveyance, arms, or ammunition, or clothing, or money, or any other gold ornaments, then it is called as harboring. So here I have completed section 6 to 52 important definitions, and in remaining 20 minutes, I think I have to cover this, property offenses as well as body offenses. However, it is, very difficult to cover these two topics immediately. Let us see, I will try to it. So, if you have any questions, you can ask me on definitions. Otherwise, sir, my lecture will be only one-way traffic. Okay?
Hello.
Yes.
Anyone have any question? About
काय
the
मराठीत विचारलं तरी चालेल.
Session is open for all. You may ask the question directly to the sir. If anyone has.
Sir, I have some doubt regarding section number 34, and you said section number 141. That is a
Yes.
common object and a common intention. Can you re-explain it, please?
Yes. Common intention, mostly intention comes only in the mind. Okay, it is like mens rea. Okay, guilty mind, do you know? And mens rea, you also know. So intention is always within the feelings of a human being. And object, common object means when the mob is gathered in front of the collector office, their common object becomes that if someone is throwing stones, they have come earlier in the morning with a morcha to the office of the collector that there some demands should be fulfilled by the government. Take for example, the ST bus, workers are on the strike. they have taken a march from ST bus stand Satara to the office of collector. Their common object was that their strike and their demands should be solved by the government or by the corporate bodies. However, they have no intention to cause any damage to the property of the government. But later on, when they come to the office of the collector, and there they come to know that their demands are not going to be fulfilled. Then somebody tries to instigate them immediately or all of a sudden, and there they here they change their object. Here they have first the object of only getting their grievance or submitting their grievances or demands to the collector office. But now someone is throwing stones, and later on, all the remaining 50 or 100 workers start pelting stones, whatever doing damage. That is called object. That is called common object. But when the intention, see, if the intention of the mob was to create damage right from the beginning, they might have brought some diesel, they might have brought some petrol, they might have brought some stones also in their bags right from the beginning. So object, common object is a product of sudden provocation, and intention is with so many thoughts, so many preparations. Intention requires some preparations. For example, if I myself or my servant wants to commit an offense, okay, so I will bring one sword, and I will also bring two swords. I will give one of the swords to him also. And if someone is coming to our house, we will attack. This is called intention, because we have done preparation for crime. We have also thought together, if someone is coming, we will hit with these swords. So this intention requires previous thinking. Intention also requires previous preparation of equipments and previous preparation of associates. Okay, but common object, it is a sudden product, and common object may change from time to time. From the beginning of the morcha, from ST bus stand, they have very good, slogans. When they reached to Poenaka, one of them was trying to instigate the people, workers. When they reached the collector office, the mob turned into an unlawful assembly. That is called object, sir. If
Yes, sir. Yes, sir. It is clear. Intention is prepared planning, and it is
yes,
prepared. Yes,
thoughtful planning.
Thoughtful planning, and object is
Object is a
may
sudden
change.
product.
It may change anytime. Okay. Thank you, sir.
Yes, it is a sudden product.
Yes, sir. Yes, sir. Yes, sir. Thank you, sir. Thank you very much. Nice you have explained. Thank you.
Yes, sir. Yes. Any other question?
Any other question from voice? Hello.
Yes. Yes. If you have no questions, I will go to straight away to
Okay.
chapter 16, that is offenses against human body. This is, very wide topic, right from section 299 to 377. All these types of offenses, and there are some definitions also. So what is culpable homicide and what is murder is always a confusion. Some people explain that under section 299, that is culpable homicide, there is no intention, but it is wrong. Even in culpable homicide, there is also an intention. There is also a knowledge that if any act which is causing death of a human being, then it is also a culpable homicide. So section 299 is regarding culpable homicide, and it defines not only the culpable homicide but also next section 300 also explains what are the four, exceptions to the definition of murder. Section 299, whoever causes death by doing an act with intention of causing death or with the intention of causing such bodily injury as is likely to cause death or with the knowledge that he is likely by such act cause death commits an offense of culpable homicide. So in section 299 also there is intention to cause death. There is also a knowledge that this act is likely to cause the death of a human being. Then what is murder? So we will have to understand what is murder under section 300 unless and until we understand four exceptions of section 300 we cannot make a difference between murder and culpable homicide, except in the cases herein after accepted, culpable homicide is a murder. What are these exceptions? If the act by which death is caused is done with the intention of causing death. The first exception is that with the intention of causing death. Here, only important point in this section 300 is that intention to cause death, and in section 299 it was intention to cause bodily injury. It was the intention to cause bodily injury, but he knows that such bodily injury may result into death. So this is first exception under IPC 300, that is only intention to cause death. Okay, so this kind of action is a murder. Secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. And third, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. And lastly, if the person committing the act knows that it is imminently dangerous to that it in all probability the cause death or such bodily injury is to cause death, commits such act without any excuse or incurring the risk of causing death. So we will take an example of Salman Khan. Salman Khan was, having alcohol drinks in one of the permit room in Mumbai. Okay. He had drunk a lot of alcohol. Okay. He was having police bodyguard also. He was having his own car driver also. However, after coming from out of the bar room or the permit room, he decided to drive the car. Even though he was under influence of alcohol, he was fully aware. He was fully aware that he should not drive. If he drives his car, he may get himself into problem or he may lead to the death of any person. However, he had decided to drive his car, and later on his car went up to the footpath and crushed 2 or 5 persons, and one of the person died in the that mishap. First of all, so many police officers thought that it is an accident, but after his medical examination found that he was heavy drunkard. He had full knowledge that he is under influence of alcohol, though he has driven this car and he was having also a driver. Then section 304 part 2, that is culpable homicide, was applied, because he knows that if he drives such car and if he meets with any, person or human being, he may die because of the dash of the accident. So he was punished by the session court for the culpable homicide not amounting to murder, because right from the beginning he was not he was not having intention to kill the persons who are sleeping on the footpath. So this exception under section 301, that he was not having right from the beginning an intention to cause the death of the sleeping persons on the footpath. So he was given this exception, that only intention was not about previous enmity, was also not with the persons sleeping on the footpath. So this action was done all of a sudden. It was not fully, prepared. That is 100%. His intention was not to kill the persons who was sleeping on the footpath. That is why the benefit under section 300 exception 1 was given to him, and it was turned to section 304 part 2. He was convicted for 5 years imprisonment. However, High Court has given him clean acquittal in the appeal immediately filed before the court. So these two sections always confuse, that is culpable homicide and the murder. But when you read section 304 exceptions, then you will understand the difference between a culpable homicide as well as the murder. Okay. Then punishment, section 302, you know, but section 303 is always missed, punishment for murder by a life convict. If someone is convicted for any life convict, here not only for murder, because there are also some offenses where the life imprisonment is also provided. Take for example, if a person or man is committing rape on a woman, and he may be convicted for life imprisonment. And if he commits another offense of murder, then he will be convicted under section 303 of IPC. That is, whoever being under sentence of life imprisonment commits murder again, then he shall be punished. Previously, it is not necessary that he should commit only a murder, but previously he was convicted for life imprisonment punishment for any offense under any law, and again he comes out of the jail and commits a murder, then straightway he will be hanged till death. The punishment under section 303 is only death penalty. So this is the only section under IPC where there is no any lesser punishment for the life convicts who have made such kind of offense. Then last section we will say, because it is time 1:20 now, section 304, that is punishment for culpable homicide not amounting to murder. These you may go into details. Last section I would like to mention here is that 304B, that is dowry tax. Latest judgment on dowry, that is, you have to go to definition of dowry under the Dowry Prohibition Act 1961, and as amended from time to time, because there is an amendment in the definition of dowry in the year 1984 also, and even also 2004. What is dowry? The dowry means any kind of agreement. It may not be written agreement, but any agreement done by either parties, not only the party of the bridegroom or the party of the bride, either parties before the marriage or after the marriage or during the marriage. These three words are important for definition of dowry. Before the marriage, during the performance of the marriage ceremony, or after the marriage. If any married woman from the date of marriage within a period of 7 years of age, 7 years of period, she dies in an unnatural manner, then and whether she was subjected to the cruelty by the husband or the in-laws of the husband or the relatives of the husband, then it amounts to dowry death. The first condition is that the offense should be committed from the date of marriage within a period of 7 years. Sometimes a woman can be married at the age of 19, and if she dies at the age of 28, okay, 19 plus 7, it is 26. However, she died at the age of 28 in an unnatural manner, then it is also a dowry death. Because a woman who commits suicide or a woman who dies in unnatural manner before the age of 30 is also treated as dowry death, as well as if a woman marries at the age of 29 years old and she dies at the age of 35, that is within 7 years, then it is also dowry death. So this is section 304B, capital B, and this is important section for your study point of view. So I think it is our time for this lecture. It is 1:20. We will complete sir remaining portion next if you uh, have any kind of suggestion. Whether I should continue for 10 minutes again. निकुम सर, लेक्चर पुढे चालू ठेवू का 10 मिनिटं का बंद करू? काय प्रश्न आहेत मुलांचे? हॅलो प्रतीक्षा भोसले.
येस सर, कंटिन्यू
कंटिन्यू
करा.
केलं तर
Yes,
चालेल
sir.
सर,
Yes, sir.
कंटिन्यू केलं तर.
Yes, sir.
10 मिनिटं चालू ठेवू का अजून?
Yes, sir. Yes, sir. Yes, sir. As per your requirement, sir. No issue.
Yes, yes, I will continue for 10 more minutes. And
Yes, sir.
remaining, because section, this I mean 304B, then attempt to murder, it is I mean very simple, but abatement of suicide 306. If any person commits suicide, whoever abates, here the abatement section, I have forgotten to tell you the definition of IPC section 107. IPC 107. What is abatement is explained in section 107 of the IPC. So let us go back to the abatement of thing. What is abatement and what is conspiracy? These are also two very confusing words. Abatement of a thing means a person abates to doing of thing who first, there are three conditions for abatement. First condition is to instigate any person to do that thing. To do that thing. Take for example, I am having a servant, male servant, okay, in my bungalow. I am instigating him. Okay, I am instigating him that our neighbors have gone somewhere else and we will steal some, I mean, coconut from the neighbor's bungalow. Okay, so I am not actually going into the compound of my neighbor, but I am sending my servant into the compound of, he is climbing on the coconut tree and he has taken 10, I mean, coconuts from the tree and he is throwing one by one towards me in my compound and I am catching those coconuts. Here I am committing an abatement. to the offense of theft. Okay, because I have instigated him. He had no wish to steal these coconuts, but I have instigated. Instigate means I have given assistance, I have given provocation, I have given guidance how to steal the coconuts. So this is first condition. If someone is instigating, someone is giving, aid, assistance, then it is abatement. Secondly, engages with one or more other person or persons in any conspiracy for the doing of that thing. And again, I am bringing some other boys to take out the all, coconuts. I am telling all other persons that these coconuts also belong to me. So go and climb and take all the coconuts. So if I am hiring any other person or doing illegal act, then it is also called as abatement. And third is intentionally aids by any act or any illegal omission of the doing of the thing. Okay. Meanwhile, what happens? Meanwhile, while stealing the coconuts, the neighbor comes there into the door. Then I am aiding him that he should come out of the compound immediately. So I am giving him a शिडी त्याला देतोय मी लगेच चढून येण्यासाठी किंवा मी त्याला हात देतोय आणि कंपाऊंडवरून ओढून घेतो आहे. सो आय एम गिव्हिंग एनी काइंड ऑफ एड अँड देन इट इज ए काइंड ऑफ abatement. So IPC section 306 is regarding abatement of suicide. If someone has given any kind of instigation, someone has engaged any person to commit any assistant and intentionally he has given any article to commit suicide, then it is called as abatement of suicide. Okay, take for example, if some person has poured himself on his body some kerosene or diesel or petrol, and I am giving him a matches box to set himself on self-immolation or self-fire, then I am also doing abatement. Okay, so these kind of three words under IPC section 107 should be understood. Unless and until the definition of abatement is understood, you cannot understand section 306 abatement of offense to commit suicide. So this section 306 is over. Okay, then section 307 attempt to murder. This is simple, but most of the times 308 section is missed, attempt to commit culpable homicide. This is also another section. Then section 309 attempt to commit suicide. Here most of the students are under wrong impression that this section is removed or abolished from the IPC. No, it is still in existence, though Bombay High Court has given the decision that this is unconstitutional. Attempt to commit suicide. Whoever attempts to commit suicide and does any act towards the commission of such offense shall be punished the simple imprisonment which may extend to 1 year. Here, does any act is important. Only a woman is crying or a woman is shouting that she is going to die, she is going to commit suicide, and she is running towards the well, okay, or she is running towards the river where there is a lot of water. However, she does not jump into the well. She does not jump into the river. She stays there only on the bank of the river or on the bank of the well. Then there is no offense. Because she has only uttered the words, she has run away, but the next act is not done. So this is incomplete act of suicide. So this offense of suicide takes place when and when only there is some act towards the commission of suicide. Only uttering the words, only running towards the bank of the river or towards the bridge and stops there does not comply the condition under section 309 of the IPC. So these are, I mean, very important definitions. Then next definition we will go to section 319. That is, what is hurt? What is hurt? Simply physical hurt. Whoever causes bodily pain. There are three ingredients under hurt. One is bodily pain. Suppose if I hit a person with a stick or my blows, then if the person gets some bodily pains, it is called hurt. If someone gets disease because of any action, suppose a person is injected with HIV, I mean virus, then he will be also the patient of HIV disease, because the blood which is injected or the syringe which is injected to him is having HIV virus. So this kind of disease, if it is caused, then it is also a hurt. Or any infirmity or inability to any person is caused, then it also comes under the definition of hurt. And last, I will explain you section 320, what are the 8 types of grievous hurts. So what are the 8 types of grievous hurts? First is emasculation. Emasculation means the testicles of any man are permanently pressed to such an extent that his ability to reproduce human being is lost, completely lost. Testicles are pressed to such an extent that he cannot produce or he cannot reproduce any human being, because that is called emasculation. So pressing of such testicles is called as emasculation. Secondly, permanent privation of the sight of either eye. Here the word is sight of the eye is important. Here the eye is not, if the only eye is damaged, suppose eyebrow is damaged or eye has some problem, injury, but the sight is not lost permanently, then it is not grievous injury. Okay, there may be some injury towards the layer of the eye, but the sight is not lost or permanently, then it does not come. Like that, if someone is, I mean, a permanent privation of the hearing of either ear, then it is also a serious or grievous injury. Or privation of the member or joint. Member or joint means bone, joint bones, knee bones, elbow bones. They are permanently having any kind of disability, then it is also a serious or grievous injury. Fifthly, destruction or permanent impairing of the powers of any member of the joint. So permanent loss to the knee or elbow or to any other bones in the body, then it is also grievous hurt. Sixthly, permanent disfiguration of the head or face. So here the permanent disfiguration of the face is caused by acid attack or any other corrosive substance. If it is thrown on the face of the human being, then it is a permanent disfiguration. But during Rang Panchami or during Holi, if someone has kept some black, I mean, color on my face, it is not a permanent disfiguration. For 1 or 2 days, if silver color is applied to my face, then it will be removed after 1 or 2 days. So if there should be some permanent disfiguration, how it will occur? If it is, I mean, done with the acid attack or any corrosive substance or any chemical then it is called a permanent disfiguration of the head or the face. Another example, now I have a bald. Okay, my hair have been lost. At least 80% hair have been lost. And if I am going to accuse any person that because of, I mean, this person, this my permanent disfiguration is done. Okay, no, it is not. It is a natural disfiguration. You see, this is the difference between permanent and natural. And seventhly, fracture or dislocation of both bone or tooth. If any tooth is lost, if any bone is dislocated, then it is also called as the serious or grievous injury. And lastly, eighthly, any hurt which endangers life or which causes the sufferers to be during the space of 20 days in severe body pains. 20 days in severe bodily pain is very important word. Cause hurt or unable to follow is ordinary pursuits. Ordinary pursuits means ordinary day-to-day workings. He is unable to go to toilet. He is unable to go to bathrooms. He is unable to walk. He is unable to even have a food on his own. These are ordinary pursuits. And if he is unable to continue for next 20 days, then it will be treated as severe injury. But only remaining in the hospital for 20 days for medical treatment, it is not a grievous injury. Okay, so this is, I mean, sufficient for today's lecture. Last 4 to 5 minutes. If you have any question, you can ask me. Otherwise, we will stop here. Okay. तर काय प्रश्न असतील ते विचारा. आपल्याला सगळं कव्हर झालेलं नाही. आय थिंक आय हॅव एक्सप्लेन्ड in detail, and it is not, I mean, expected to be explained in so much detail.
Hello. Yes, sir. Any student have any questions? Anyone have any question? Forum is open for all. They may ask the question directly to the respected sir. Hello, am I audible to you?
Yes, sir. Yes, sir. काय विद्यार्थ्यांना काय प्रश्न आहेत का नाही का काय समजलं नाही?
एक तर प्रश्न नाही आहेत किंवा त्यांना समजलं नाही, अशा दोनच गोष्टी होऊ शकतात. पण मला असं वाटतं विद्यार्थ्यांना नक्कीच समजलाय सर, कारण आयपीसी हा त्यांना आता ह्या सेमिस्टरला पण होता आणि
गुड
येस सर, आणि बाकीचे जे विद्यार्थी आहेत त्यांना आयपीसी झालेला आहे, त्यामुळे दे आर वेल नोन अबाउट द आयपीसी.
येस.
सो आय थिंक they don't have any question. I think one of the question. Yes, sir.
Hello,
nice.
sir.
Yes.
Sir, culpable homicide, मर्डर आणि मर्डर मधला मग एक्झॅक्टली डिफरन्स, कारण इंटेन्शन दोन्हीकडे पण आहे, कॉझिंग डेथ दोन्हीकडे पण आहे आणि नॉलेज पण दोन्ही प्रोव्हिजन मध्ये आहे. तर मग एक्झॅक्टली डिफरन्स काय आहे सर? म्हणजे स्लाइटर डिफरन्स काय? बाय
मर्डर डेफिनेशन इन्क्लूड्स some, I mean, intention along with some preparations. Okay, some preparations. Preparation in the sense of preparation with weapons, dangerous weapons. Then preparation with some other associates. Preparation with some other associates. And some motive should be there also. This motive is always missing in culpable homicide, and in murder cases motive is always there. So it is very difficult to, I mean, uncover the motive, because motive is the next step of intention. Okay, see, motive is the next step or stage of intention. So this motive is missing in culpable homicide because it takes all of a sudden. Like Salman Khan was not having a motive to kill the people sleeping on the footpath. So he was taken towards that case. So please keep in mind the most important difference between culpable homicide and murder is that in a murder case there is always a motive. Okay, there is always a preparation of crime. There is, preparation of associates, and there is some planning in murder case. But in culpable homicide, sometimes he knows that he has a revolver. If he fires it, the person may die, but he kills. That is called all of sudden action. Culpable homicide, death occurs out of the sudden fight or sudden situation. That is called culpable homicide. And in motive is missing in culpable homicide. Yes.
I think
फरक लक्षात ठेवा.
ओके सर. सर अजून एक क्वेश्चन होता. सर सेक्शन 34 मध्ये कॉमन इंटेन्शन आपण बघितलं होतं. कॉमन इंटेन्शन आणि सेम इंटेन्शन, म्हणजे कॉमन इंटेन्शन म्हणतो तेव्हा क्रिमिनल कॉन्स्पिरसीच्या पॉइंट ऑफ व्ह्यू न ते पटकन क्लिक होतं, पण तसं सेम इंटेन्शन, इज देअर एनी बायफ्रिकेशन सर?
सेम इंटेन्शन आहे ना, हे ऍक्च्युली का नाही असा लिगल वर्ड नाही, परंतु आपण काय करतो ते सेम इंटेन्शन कशा प्रकारे आणायला बघतो की आपल्या सर्वांचा येतो, पण तो सेम इंटेन्शन मध्ये जात नाही, तो कॉमन ऑब्जेक्ट मध्ये जातो. ते अचानक दंगल उसळते, त्यानंतर मग ते लोक दगडफेक चालू करतात, मग त्याच्यामध्ये जे जातं त्याला म्हणायचं कॉमन ऑब्जेक्ट. पण सेम इंटेन्शन असा शब्द मी तरी ऐकलेला नाही कुठल्या लिगल अशा टर्मिनॉलॉजी मध्ये अजून. बट कॉमन इज देअर, कॉमन इंटेन्शन अमंग सेव्हरल पर्सन्स. सो 141 आणि सेक्शन 34 आणि 107 आणि 120B हे थोडेसे अजून एकदा तुम्हाला समजावून सांगेन मी पुन्हा एकदा. तरी पण अजून काय प्रश्न असेल तर विचारा. ओके.
थँक्यू सर.
Okay. Anyone have any question?
सर एक क्वेश्चन होता मला.
हा.
सर जर कोणता अक्युज्ड असेल तर त्यासाठी CRPC मध्ये 41D मध्ये राईट ऑफ अरेस्टेड पर्सन टू मीट अँड ॲडव्होकेट ऑफ हिज चॉईस ड्युरिंग इंट्रोगेशन असं त्यासाठी राईट आहे.
हो.
पण सर ज्याच्या म्हणजे जो विक्टिम आहे तो पोलीस स्टेशन मध्ये जाताना वकिलाला घेऊन जाऊ शकतो सोबत, असं कोणतं प्रोव्हिजन आहे का?
नाही, वकिलासोबतच गेलं पाहिजे असं काय नाही. DK बसू गाईडलाईन मध्ये असं म्हटलेलं आहे.
हा, कारण की सर काय आहे, एक 354चं मॅटर होतं त्याच्यामध्ये ते जे आपले विक्टिम आहेत ते पहिले पोलीस स्टेशनला गेले, तेव्हा त्यांची NC नोंदवली घेतली नाही, म्हणजे पोलिसांनी काहीच दखल घेतली नाही त्या मॅटरची. त्याच्यानंतर मग त्यांच्यासोबत वकील गेले. ते पोलीस वकिलाला प्रश्न विचारायला लागले की तुम्ही कोणत्या ह्याच्यानुसार आलाय विक्टिम सोबत, तुम्हाला हक्क नाही विक्टिम सोबत येण्यासाठी, त्यासाठी काय प्रोव्हिजन आहे सर?
हा, विक्टिम सोबत आहे ना, विक्टिम कुठल्या विक्टिम हे बघितलं पाहिजे. बघा, विक्टिम ऑफ रेप आणि विक्टिम ऑफ मोलेस्टेशन म्हणजे IPC 354, 376, 300 याच्यामधल्या ज्या व्यक्ती आहेत ना, यांना लिगली त्यांच्या चॉईसनं त्यांचा नातेवाईक किंवा वकिलाला
354चं मॅटर होतं सर.
354 मध्ये आहे, 354 मध्ये आणि 376 मध्ये आहे. त्यांच्या चॉईसच्या व्यक्तीसोबत ते जाऊ शकतात, त्यामध्ये वकील जाऊ शकतात. परंतु वकिलाने तिथे त्यांना सजेशन काय द्यायचं नाही. ओनली ही कॅन अकंपनी. तुम्ही 41D CRPC मध्ये पण बघा, ही कॅन मीट द ऍडव्होकेट म्हणलंय, मीट म्हणलंय. इथं ही कॅन कन्सल्ट म्हणलेलं नाही. अॅक्युज कॅनॉट कन्सल्ट, बट अॅक्युज कॅन मीट हिज ऍडव्होकेट. कन्सल्ट मीन्स मी कुठली पोलिसाला उत्तर देऊ, कुठली देऊ नको.
आवाज येत नाही सर तुमचा.
एक मिनिट. कोणत्या प्रश्नाची उत्तर द्यावीत आणि कोणत्या प्रश्नाची उत्तर देऊ नयेत असं कन्सल्टेशन करता येत नाही. त्यांना फक्त भेटायला वकीलपत्रावर सही करायला त्याला कुठं फिजिकल टॉर्चर होत आहे का एवढंच पाहण्याचा अधिकार वकिलांना सेक्शन 41D खाली आहे. त्याला इंटरोगेशन दरम्यान 100% थ्रू आउट द इंटरोगेशन थांबता येत नाही वकिलांना. ठराविक वेळेस थांबता येईल. त्यामुळं व्यक्त विक्टिम ऑफ रेप आणि मोलेस्टेशन विनयभंग एवढ्या मधल्या फिर्यादीला स्वतःच्या वकिलासोबत नातेवाईकासोबत जाण्याचा अधिकार कायद्यात दिलेला आहे, IPC मध्ये दिलेला आहे. येस. अजून काय
I think no one have yes no one have any question if I'm not wrong. Okay, so rightly nice sir nicely explain each and every facets of the IPC. Definitely rest of the students they don't have any question about the said matter too. So I would like to call up Pratiksha to take the charge.
Yes, sir. Thank you, sir, for sharing with us valuable knowledge and relevant examples. You have delivered such an informative session and it's very useful for us. Now I would like to request Mayuri Jadhav to give word of thanks. Over to you, Mayuri.
Thank you, Pratiksha. Myself, Mayuri Jadhav from 3rd NLC. I would like to thank our college, Ismail Sahib Mullah Law College, Satara, Principal Ma'am Dr. Sujata Pawar, IMS Satara, and Career Katta for organizing JMFC Lecture Series. I am grateful to Honorable Shri Sambhaji Patil sir for telling us so much about IPC definitions, offences against property, and taking time from your schedule to guide us all. I would also like to thank Shri Anup Mugli sir for the technical support, Pratiksha Bhosle for anchoring, Pratiksha Kaldhone for introducing our honorable guest, and last but not the least, thank you all for joining today's lecture. With the principal ma'am permission, I hereby declare that today's lecture is over. Thank you one and all, and have a great day.
Thanks to all.
Thank you, sir. Thank you, sir.